Okay, I want to do another video for you. My name's Randy Miller, founder of Your American Sheriffs, trying to educate and inform as many people as possible on our constitutions and just what is happening that is wrong for America, wrong for every citizen of every sovereign state, and the actions within the states that need to be stopped because it's taking over and eroding individual liberties that's protected by the Constitution. So this one is a remake, kind of, for an Arizona proposition that is on the ballots. Many states have these, and some of them already enacted them, which is very destructive. In Arizona, it's Prop 135, which is granting authority to the governor to declare a state of emergency, which is, I'm going to explain just how that is a disaster and why it is unconstitutional for Arizona and for any state in the country. But I'm going to focus on our statutes. I did one previously, but I didn't have the ability at the time to do a slide presentation, which I'm going to do now. So this video will have slides that you can stop the video and take screenshots of them for reference if you want to. And I hope to keep it at about 30 minutes. I don't want to do long videos because I know we're all busy and I respect your time, but I want the information out. So let's do the first. Let me start the slides. This is again on granting emergency powers to the governor, which is absurd. And the first slide is questions on state powers. This is sponsored by the Arizona Free Enterprise Club, specifically Amy Yentes and her group. And I've had discussions with her, tried to have discussions with her, but she's unwilling to listen. And even an attorney from the Goldwater Institute, who has no idea what I was talking about, claims the Constitution's a separate issue. Give me a break. So I want to do this presentation and inform you that this is just absolutely wrong. And it is not anything that the Arizona Free Enterprise Club is really that free enterprise. Then why did she support actions of the governor that shuts down business, which is free enterprise, and where 50% of those businesses reportedly did not reopen after they were shut down unconstitutionally? So let's get into it. HCR 2039, which is now Prop 135, is not doing nothing more than legalizing unconstitutional laws on the books today. Current law allows the governor to make law through orders, policy, and directives, basically governing us by proclamation. The governor can currently force vaccinate, illegally detain you, house and hold citizens without due process rights, and this happened. These laws violate many sections of Arizona's Constitution and are not in balance with, at the time, the 2016 Republican platform, which is they believe in support the Constitution. No Republican would ever support this, yet every single Republican in Arizona in the state legislature sponsored and supported, didn't sponsor, but it was sponsored by a Republican, and every single one of them voted for it. No Republican would support this and should be removed from office. Absolutely. That's my opinion. Current laws should have been rescinded rather than an attempt to legalize them by a constitutional amendment forced on the people, misleading them to believe it's a good thing. Now, there are situations where, yes, we want to protect the public. Typhoid Mary was a carrier of typhoid. She wasn't, excuse me, I didn't mean to bump that. She wasn't infected with the disease herself and sick, but she was a carrier and she was spreading it because she was a cook. And she had infected people died, and they traced it back to her. And she was told, hey, look, you're a carrier. And if you stop cooking and providing food where you're contaminating the food at times and spreading it, you'll be fine. She refused to do that. She continued to cook. That was the only way she could make a living, and continued to spread it, knowing she was spreading typhoid and basically killing people and making them very sick. So they locked her up because she refused. These are situations where when an individual is a danger to society and intentionally harming people, we need to intercede. But you don't need to declare a state of emergency to do that. It's an individual basis. The other one is if you got idiots shooting the firearm randomly and spreading a dangerous environment to innocent bystanders, innocent people. You just don't do that. Again, this is something where we have laws on the books, and you don't declare a state of emergency every time someone threatens an individual and you need to protect them. You just deal with it in a law enforcement manner, and you have laws on the books that went through the process of vetting and making sure that they're not violating individual rights when you implement the law. The purpose of government is to protect the rights of the individual. What does that mean? Our individual rights come with an individual responsibility, like these people who were violating other people's rights, spreading typhoid or shooting randomly in the streets or irresponsibly or even deliberately. We can exercise our rights as long as they don't impose on the rights of another. All rights are natural rights, those that we are endowed with by our Creator, God-given rights. Because this is self-evident, as stated in the Bill of Rights, or the Declaration of Independence, we must understand that we are all created equal and have no more rights than the person sitting next to you now, or your neighbor. We have a duty to protect their rights as much as we do to protect our own. Remember what happened. Here's what happens when you allow a governor, some wingnut basket case that thinks he's an authoritarian and has every right over your liberties and civil rights. Thanksgiving, Gavin Newsom, no more than 3 people per household present, parties no longer than 2 hours, because COVID's smart. If you're there for longer than 2 hours, it's going to suddenly invade. Guests must stay outside. Are you kidding me? And avoid singing, chanting, or shouting. Who comes up with this? Newsom does, obviously. Colorado, Sagachi County adopts an emergency regulations allowing warrantless entry to private property and preventing sale of firearms and ammo. They abuse the power. You give them power, they're going to abuse it any way they can because it's an emergency. Same thing they did with elections. That's what it was designed for. Crisis Factory, New York to declare a state of emergency due to staffing shortages caused by the government's COVID vaccine mandates. So what does she do? She declares a state of emergency because there's a shortage of medical staff, and she calls the National Guard to replace 72,000 unvaccinated healthcare workers. CDC has community reception centers in their policy. This is for radiologic contamination or emergency, but they have community reception center. The system's already in place. They can use it for anything they want. And shelter resources for radiation emergencies. So they have reception centers is what they call them. And this is a green zone. This is a document. I'm going to have to read this one because I can't read that small print there. This document presents considerations from the perspective of the U.S. Centers for Disease Control and Prevention, Fauci mindset, for the implementing the shielding approach in humanitarian settings as outlined in guidance documents focused on camps, displacement or displaced populations, and low resource settings. So right there, they already tell you camp. And this is by the Center for Disease Control. What is the shielding approach? It aims to reduce the number of severe COVID-19 cases by limiting contact between individuals at higher risk of developing severe disease. They didn't say COVID, they said severe disease. The general population is low risk, and the high risk are those that are at risk of developing disease. And they're going to determine that on their own. High-risk individuals would be temporarily relocated to safe or green zones. Now, that's a very risky proposition in and of itself, and I'll explain that as we get into some of the laws on the books currently that are unconstitutional. So we got to understand that they already have a system in place nationally, which is unconstitutional. The CDC is not an authority over the states. There's no constitutional authority for them to have any authority over us, And we need to understand that this is nothing more than a power grab and usurpation of power from the states and the individual citizens. This one hits home. Our mayor, if you want to see an example of the walking dead, we're talking about brain dead, it's our mayor of Phoenix. She wanted the Biden administration, who has no constitutional authority to declare a state of emergency himself, to declare Arizona heat a federal emergency. So the heat of Arizona, the fact that we live in the desert, we choose to live here in the desert, knowing it's hot, it needs to become a national emergency because Arizona's hot. Walking Dead, hello. Here's current laws that we have on the books right now. Section ARS, Arizona Revised Statute, Section 26303. Now, if you need to copy this, just stop your video and make a screenshot. Emergency powers of the governor termination. So here we go. Our Prop 135 is being presented to the people to say that, hey, we're just limiting the power of the governor to a 30-day time period, and restricting the authority to that's what's already on law today. This is already on law. So why do they need to put a constitutional amendment limiting the authority when they wrote a law limiting the authority already? And if they have the power to adjust this law, just adjust it, because it's unconstitutional, and they want to solidify it in the Constitution and grant them power over you. So 26303 says, beginning January 2nd, 2023, the governor may issue an initial proclamation with respect to a state of emergency for a public health emergency, as described in section 36787. We'll get there. For a period of not more than 30 days. The governor may extend the state of emergency for not more than 120 days, so that's 150 days total, but any extension may not be for a period of more than 30 days. The state of emergency shall terminate after 120 days unless the state of emergency is extended by passage of concurrent resolution of the legislature. So the legislature clearly wants to have this power among themselves as well. Why? Funding, federal funding comes into the state, and they want that money because they can't manage our money themselves. The legislature can extend the emergency as many times as necessary by concurrent resolution, but any extension may not be for a period of more than 30 days at a time. ARS 26303 E. During a state of emergency, the governor shall have complete authority over all agencies of the state government and the right to exercise within area designated, the whole state in this case, all police power vested in this state by the Constitution. I ask you to show me where police power is even granted to the government in our state constitution. It's not there. It's not under Article 4. It's not under Article 5. And the laws of the state in order to effectuate the purpose of this chapter. So they're not even talking about the Constitution. They're saying that the laws that the legislature makes, the governor will follow those. Regardless of if the laws are constitutional or not, and they are not. ARS, that should be 26311. I apologize, I missed it too. Local emergencies, declaration by mayor. So not only do they grant it to the governor, but now the local mayor or county board of supervisor, if a mayor or of an incorporated city or town or the chairman of the board of supervisors in any county you live in Arizona, and I'm sure many states have similar laws like this, for the unincorporated areas of the county, deems that an emergency exists due to fire, conflagration, flood, earthquake, explosion, war, bombing, acts of the enemy, or any other natural or man-made calamity or disaster or threats, the mayor or chairman of the board of supervisors, if authorized by the ordinance or resolution, may declare by proclamation on their own an emergency or a local emergency exists. What that means is that if the city, town, or the county passes a proclamation or an ordinance that grants power to the chairman of the board of supervisors or the mayor to declare a state of emergency, they can. One person, no representation of any of the other people that the residents in the district of the county or the city vote for to represent them as a voice, no representation, that one individual has the authority to, by proclamation, declare a state of emergency. ARS 26311. Local emergencies continued. I misspelled continued. Sorry about that. B, 26311B, pursuant to this subsection A of this pursuant to subsection A of this section, the mayor or the chairman of the board of supervisors shall govern during such an emergency by proclamation. That means whatever they come up with, no laws, just by proclamation. Every time they write down an order, that's the current law that the local authorities will follow, and shall have the authority to impose all necessary regulations to preserve the peace and order. Some of this I get, but when we're talking about health emergencies and things like that, this is way out of line. And you still have to have representation of the people that you vote with collectively, the heads coming together of all the representation of the people coming up with decisions, not giving it to one individual. That is, we're not making kings. Well, evidently we are, but we're not supposed to. ARS 26314, immunity. This is lovely. Of state political subdivisions and officers, agents, employees, and emergency workers, the state and its departments, agencies, board and commissions, and all political subdivisions are not liable for any claim based on the exercise or performance or the failure to exercise or perform a discretionary function or duty of any emergency worker, except for willful misconduct, gross negligence, or bad faith of the emergency worker in engaging in emergency management activities or performing emergency functions pursuant to this chapter or Title 36, Chapter 6, Article 9. We'll get to that. You can read those, including operation of unmanned aircraft or public unmanned aircraft while engaged in supporting emergency management. So basically what they're saying is when a proclamation is made by a local authority or the governor, and they give orders, not laws, orders by proclamation, people are bound to follow that. And if it causes harm, they're not liable. We're following orders. I believe they said the same thing during the Nuremberg trials, right before they hung them. I was just following orders, violating the rights of the people, locking people up, jabbing them in the arm. You can just take that wherever you want, but basically it's ridiculous. 26316, emergency orders and rules and regulations, enforcement of orders, rules and regulations. It doesn't say laws, enforcement of rules, orders, and regulations. Law enforcement authorities of the state and political subdivisions shall enforce the orders, rules, and regulations of the king issued pursuant to this chapter. ARS 26317, violation. Any person who violates any provision of this chapter or who knowingly fails or refuses to obey any lawful order, give me a break, or regulation issued as provided in this chapter shall be guilty of a Class 1 misdemeanor. So you're guilty of a crime for failing to follow the orders of a king and not have any representation in any decisions made or your due process rights followed. This provision does not apply to the refusal of any private organization, isn't this amazing, or member thereof to participate in a local emergency or state of emergency as defined in this chapter. So if you're a member of a private agency, let's say you want to become part of Your American Sheriffs, which is my organization. I'm a member of Your American Sheriffs. I don't want to participate in your bullshit. And I don't have to participate in any of your orders or state of emergency. You're exempt? Well, tell me this isn't confusing and ridiculous. I don't understand this law at all, how they came up with that. So, and where's the equal protection of the laws? Anyway, ARS 36114, limitation upon authority to impose treatment. Here, you like this. Nothing in this title shall authorize a department or any of its officers or representatives to impose on any person against his will any mode of treatment, provided that, this is actually in the law, They can't impose it as long as you follow our orders, as provided that sanitary or preventative measures and quarantine laws are complied with by the person. So if you say, hey, I'm not going to do this, it's against my beliefs, they say now they're going to put any restrictions on you they want to, quarantine or sanitary, and they're going to say if you don't follow these, now we can impose it, provided that. So they can, whatever ridiculous sanitary thing they say, you got to wash your hands every 5 minutes or every time you sneeze and you use your arm to conceal that. Oh, and we're going to have to monitor you. How are they going to enforce these sanitary provisions? How are they going to know if you're following them? Is there going to be some intrusion on your life to do that? It's ridiculous. Nothing in this title shall authorize the department or any of its officers or representatives to impose on any person contrary to his religious concepts any mode of treatment. Again, provided that sanitary and preventative measures and quarantine laws are complied with by the person. You say, I'm Christian, I'm Catholic, we don't believe in that. I'm not going to wear the mask. Well, the mask is one of those sanitary mandatory things they want you to do, and you refuse to do that. So what does that mean? Now they can impose a shot on you. They can force quarantine you with a group. That's kind of what I get out of it. Tell me what you think. 36787, public health authority during state of emergency or state of war emergency. There's no state of emergency allowed in the Constitution, and there's no need for a state of war emergency. That's not in the Constitution as well. If you have a war, you don't need some idiot like Newsom to sit down and think about it and say, gee, we're being attacked. Do I need to declare an emergency, a war emergency, before I can do anything? No, bonehead. You just respond to it to defend the safety of the people, and the people are participants in that. And I'll get into that as well. During the state of emergency or state of war emergency, which doesn't exist, proclaimed by the idiot governor, in which there is an occurrence or imminent threat of an illness or health condition that is caused by bioterrorism, epidemic, or pandemic disease or highly fatal infectious agent or biological toxin, blah, blah, blah. You can read it. Coordinate the governor shall coordinate all matters pertaining to the public health emergency response of the state. The department has primary jurisdiction, responsibility, and authority for. Now I put that in there, the WHO quote treaty, giving them authority to declare state of emergency, giving the WHO the authority to declare state of emergency. This is going to be a snowball effect on us, so pay attention to that. So they have the sole authority over all the jurisdiction and primary responsibility for C. I didn't list them, but coordinating the medical emergency with and delegating authority to lower subordinates in agencies to control how we behave. You have to read that section. 36787, public authority, health authority during state of emergency continued if the governor believes there is an occurrence or the imminent threat of smallpox, plague, viral hemorrhagic fevers. That's interesting because remember they were talking about Marburg as a problem. That's a hemorrhagic fever. They had this in the law years ago to make sure that that's covered. Smallpox is another one that's stored in by government and other agencies or even non-agencies for war purposes. Smallpox is prevalent out there. They were playing with that decades ago. So it's interesting that's in here. The governor, in consultation with the director of the Department of Health Services, may issue orders that mandate treatment or vaccination of persons. Now remember, they said they can't force it, provided that you follow all their orders, mandate treatment or vaccination of persons who are diagnosed with or an illness resulting from exposure, or who are reasonably believed to have been exposed, or may have reasonably be expected to be exposed. Any person may refuse vaccination required as paragraph based on the person's personal beliefs, but remember, go back to the previous one we talked about, provided that. Isolate and quarantine you. Law enforcement office officials of this state and the National Guard shall enforce orders issued by the government, the National Guard. Let's back up here a second. So If they suspect you've been exposed, showing symptoms, they can quarantine you. If they believe that you may have been exposed, they can quarantine you or force vaccinate you. If they believe that it's possible you will be exposed in the future, in fact, what that means is anytime you leave your house, they may quarantine you or force vaccinate you. And they can use the National Guard to enforce orders issued by the governor. That's the military of the state. And I'm going to get into why that's unconstitutional. Due process rights, isolation, quarantine. This is interesting. The department or local health authority may isolate or quarantine a person or group of persons. Remember the previous one. If they suspect you've been exposed, you may have been exposed, or they think you may be exposed later on down the road if you leave the house. So they may quarantine you or a group of persons, your family, your neighborhood, your church, your school, your work center, your work location, without obtaining a written order from the court. They can do it by a written directive without first obtaining an order of the court. No due process rights. You're going to be detained. Quarantine of the person would impose an immediate and serious threat of health. Okay, so if they believe, so you got a health official who's acting on the belief that they're going to get more federal funds for their departments or whatever, or they're overzealous in their interpretation. This is left to the health department official to determine. If a number of people makes it impractical to serve, so if there's a lot of people, say you got 100 people, 50 people, and it's not practical for them to serve individually, when you're quarantined in a facility or location or camp, as the CDC says, all they have to do is place an order on the wall in a conspicuous place. So there's your notice. We're going to post it on the wall for you, and it's upon you guys to read it all. You're not supposed to spread it, so you got social distance. So you take turns while you're reading the notice on the wall. They must file a petition to court within 10 days of the detention. They're acknowledging you're detained, and they have 10 days to file in the court a petition. The court has 5 calendar days to put it on calendar. So that's 15 days you're detained. And if good cause is showing, the department can ask for a 10-day continuance. So you can be detained for nearly a month before you have a group appearance in court. You don't think if there's 100 people detained or a whole town, that they're going to appear individually? No, they're not appearing. Who's appearing is only that representative from the health department to justify their continued detention of you and whoever you're detained with. No due process rights, no representation in court that I can see. And let me point this out. When I was working and we made an arrest, if you're detained, we had to have a petition filed or a complaint filed with the DA, would file it within 48 hours, and you had to be in court within 70 on that third day, 72 hours. Here, any overzealous individual from the health department who has no law training whatsoever, and it could be somebody just sits at the desk filing paperwork. They go out and they're now all of a sudden they're making determination. Now they're detaining you for 25 days before you have to be in, before you're you're not even appearing in court, but before court is held. Completely wrong. This is a tyranny at its highest form. Constitution section violated. Arizona Article 2 is our Declaration of Rights. Now, you can copy this, but Declaration of Rights is like the Bill of Rights in the U.S. Constitution. Political power, purpose of government. All political power is inherent in the people. We have the political power. We loan it to these people that are going to detain you for 25 days, not represent you, and give it to one individual to declare a state of emergency and then govern you by proclamation. Political power belongs to us, not these people. And the purpose of government is that they're to maintain and preserve individual rights. What they do is they get their just powers from the consent of the governed. Nobody consented to this. Due process of law, that's violated. We just talked about it with detention. Right of the petition and of assembly. We were prevented from going out and assembling together without harassment of law enforcement or other agencies because of the emergency. So write a petition and of assembly. We were denied any conversation. When you petition your government for redress of grievances, redress is a verb. It's a discussion. They're not to just sit up there, put their feet up on the dais and listen and pretend to listen to you. And then when you're done, cut you off when you're speaking and say your time is up and go on the next person and then ignore us. That's not redress of grievances. It's a discussion process to hear the complaints and find a resolution. You can go back to, I think it's Article 64 of the Magna Carta, where they talked about what they had to do to avoid a revolution of the people. Petition the government, assembly, talk about that. Freedom of speech in the press. How many people are censored when they're talking about the other facts that counter what they say? Tyranny. Oaths and affirmation. Every single individual that put these laws on the books and voted for emergency powers, violated their oath of office, should be removed. Right to privacy, Article 2, Section 8. You shall be protected in your private affairs. That was violated. Excuse me, I got the hiccups. Irrevocable grants and privileges, franchises, or immunities. Remember, they granted immunities to any government worker, contractor, or responder. If they're following the order, not a law, the order, then they're not liable for any damages they cause to you. Administration of justice. This is saying that all justice shall be open and expedient. So how many court systems, our state Supreme Court justice put an order out that said there'll be no visitors in court? Well, you violated that section of the Constitution. Our justice system is to be open so people can witness it and observe and make sure that we aren't being unfairly prosecuted and no kabuki theaters happening against an individual. We are to monitor our justice. You cannot tell us we cannot witness a system of justice being executed upon the people. Equal privileges and immunities. Businesses were shut down. In Arizona, if you have a license that's primarily for alcohol, COVID's so smart that it knows that, hey, you're a bar, you serve more alcohol than food, so you got to shut down. You are a restaurant, you serve a little more food than alcohol, you can stay open, but you have to close 50% of your business customers that you accept into your business, because COVID's smart. It'll go to a bar, but it won't go to a restaurant. And the other thing is you have to wear a mask while you walk to your table. But once you sit down, now you can take your mask off. What about all the plates that come to your table? Who prepared your food? Who handled the silverware? Who sat there prior to you? It's insanity. Habeas corpus. Bring the body to court. So if you go to court, you have a right to appear before that judge, and the people have a right to witness your appearance before that judge. I really question the idea that, well, we're going to do it all by telephone. I don't think that's appropriate. I don't think it's proper. That needs to be looked at. Military power, subordinate civil power. Remember that section that said that the governor can implement or can call forth the National Guard to enforce the laws of the state. First of all, the governor's to enact the laws of the state to the best of their ability. The National Guard is a military. Military power is strict subordination to civil powers, what it says. You can't call the military for anything within the state. Why? Because Article 1, Section 8, Clause 15 is the militia clause. Congress shall have the power to call forth the militia to execute the laws of the United States, suppress insurrection, and repel invasions. The people are the safety net between our government and their actions. The military has no authority within the state, or even the U.S. military has no authority within the United States. It's the people. Constitutional provisions are mandatory. Well, guess what? We just went through all this stuff. They're mandatory, but yet they violated them. Our legislators, Republicans, thank you, violated that as in every aspect of the word, that mandatory. Reservation of rights. That's just like the Ninth Amendment in the U.S. Constitution. Just because the rights aren't listed does not deny or disparage those retained by the people. Now, let me go over this real quick. What's the main reasons that these are all violated as well is Article 3, distribution of powers. We have three departments. They call them departments, not branches. We have legislative, executive, and judiciary. And it says not one department shall exercise the power or authority of another. So when you grant powers to the governor to declare state of emergency and write law through proclamation, you violated separate distribution of powers. You also violated the checks and balances of the system to make sure not one department becomes more powerful than the other. Well, they just created a supreme power by making the governor a king. Section 4, Article 25, continuity of government operations in emergency. This section is the only part that mentions emergency. And this section refers to during time of war, enemy attack during time of war. What's the function that they're to do? Make sure that there's continuity of government, that government services continue during this emergency. Our roads are open so we can respond. Electricity's maintained so we can communicate back and forth. Emergency services are available so people can have the needs met that they need if they're wounded or injured. Those type of things. It has no authority over the people. They have no authority to shut us down when we are part of that response, because Article 2, Section 26 says that the right of the citizen, not non-citizen, the right of the citizen to be armed in defense of themselves or the state shall not be impaired. That is our right. And you cannot make any law that says, no, we're going to defend the state. You guys just sit at home, locked down, and let us take care of everything. No, the government belongs to the people, us. Article 5, Sections 3, 4, 5, 6, and 7. Actually, I believe 6 and 7 are just pertaining to filling vacancies of the governor and impeachment and stuff. So, but it's 3, 4, and 5 are the actual powers of the governor. This not in there to declare a state of emergency. The powers are very specific what the governor can do, and they're listed in 3, 4, and 5. Article 5, Section 9, powers and duties of state officers. Powers and duties of the lieutenant governor is coming. We just voted that in Arizona, and 2026 we'll be voting for lieutenant governor. But Section 9 is the powers and duties of the state officers. Every state officer has a constitutional existence. Their powers and duties come from the legislature. Arizona Free Enterprise Club says the legislature has inherent power to delegate authority powers to the governor. Clearly, this is wrong. Who has the inherent power? All political power is inherent in the people. I think this is an example of just how ignorant Arizona Free Enterprise Club is, or nefarious for proposing this, and Amy Yenta specifically, because she says, the legislature has inherent power to do whatever the hell they want to. Give me a break, Amy. She refused to have any discussion, public discussion with me on any of this. And I question I don't question, I know why. She doesn't want to because she can't support anything that she wants to do. Constitution sections violate, no authority continued. Article 27 of Arizona's Constitution is medical rights. Article 27, Section 2A, to preserve the freedom of Arizonans to provide for their health care. Wow. Okay. Our Constitution says this: a law or rule shall not compel, directly or indirectly, any person, employer, or healthcare provider to participate in a healthcare system. CDC forced hospitals to follow theirs. Why? It wasn't a force. Money. Hospitals cared more about money. They made more money off the entrance of a COVID patient to their execution all through the process. They made money on every step. Any employer cannot force you to mandate. Well, how many employers said you can't work here if you don't have a vaccine? Or any person. Now, what does it say? to participate in a healthcare system. And then let's look at definitions, section D. For purpose of this section, lawful healthcare services means any health-related service or treatment to the extent of the service or treatment is permitted or not permitted by law or regulation. So if it's permitted by law, government can say, hey, we recommend you take this clot shot and gamble with your life. Well, if the individual chooses to take that because they want to, that's up to them. But you cannot be compelled by fear or fine to participate. That's exactly what they did. They violated this section of the Constitution. Now let's get into specifics of what Arizona's Declaration of Rights is. I already mentioned Article 2, Section 2. It says all political powers inherent in the people, not the legislature, Amy, the people. And governments derive their just powers from our consent, free enterprise clause, not mandate of the governor. And their reason and existence is to protect and maintain individual rights. Now, how does this fit in with what Madison said? Federalist 46, I really like this. 46 is a section of or a paper of the Federalist by Madison where he explains when somebody, an anti-federalist was complaining, who's going to intercede between the states and the federal government when they compete for power over one another. And what he says is that the federal and state governments are in fact but different agents and trustees of the people. Let that sink in. They are agents and trustees of the people, state and federal, constituted with different powers, clearly. Very limited powers for the federal government is defined under Article 1, Section 8 for the legislature, Article 2, Section 2 for the executive, and Article 3, Section 2 for the judiciary. Very limited powers for them, but they expand that all the time. They're constituted with different powers and designed for different purposes. Absolutely. The adversaries of the Constitution seem to have lost sight of the people altogether in their reasonings on this subject, meaning disputes between the states. Who's going to control one or the other? And to have viewed these different establishments not only as mutual rivals and enemies, but as uncontrolled by any common superior. As being uncontrolled by any common superior in their efforts to usurp the authorities of each other. Federal government's been usurping power over the states for decades, and we've got to stop it. These gentlemen must be reminded of their error when they say that there's no common or a common superior over these forces. Madison says you need to be reminded of your error in that thought. They must be told that the ultimate authority, wherever the derivative may be found, resides in the people alone, resides in you, resides in us collectively. We are the ultimate authority over these governments, and that it will not depend merely on the comparative ambition or address of the different governments, whether either or which of them will be able to enlarge its sphere of jurisdiction at the expense of the other. The courts have been assisting the federal government in expanding their powers and jurisdictions. They're a creation of the government's part of the system of government by the people. They're no less responsible to the people than the other branches. We have to recognize that we are the common superior force over this government. And when you get to the ballot box and there's any constitutional amendment proposed to a state constitution, be very, very cautious of the verbiage. They use these flowery terms and words to make you think, oh, look at how wonderful this is. A perfect example of that is the Patriot Act. There's nothing patriotic about that. It needs to go. So just be very careful and remember what our authority is and who the government belongs to. I hope I'm going to stop now because I've given you a lot. I want to keep these short, and this is a long one, and I apologize. My other ones will be 10 to 12 minutes just to talk about specific issues and sections. Please leave comments, and if you like what I'm presenting, hit the like button and share. It's a new channel, and I could use the help. Thank you very much. I'm Randy Miller, your American Sheriffs, and let's get our sheriffs on board with our constitutions and supporting the people. Thank you.